Greetings, everyone. A very good evening to all of you present here. I, Paraschuk, a member of Legal Vidya, welcome you all on the 20th class of the 45 days Advanced Legal Drafting Certificate course by Legal Vidya. So, without further ado, let's warmly welcome our esteemed speaker, Ms. Shivani Gupta ma'am, to the virtual stage. Welcome, ma'am.
Good evening, Legal Vidya, and good evening, participants present over here. So, we'll start the class. Wait, just I'm sharing the screen. And for today's class, there is no as such a draft. Actually, today we have to discuss about a few concepts regarding the Indian Evidence Act. Actually, there are two things that are being in the session, and first of all is the evidentiary value of the electronic record. That's why I didn't share any PDF or something notes before the session, because there was no as such relevancy of sharing the same. Wait, I'm sharing the screen. I hope the screen is visible to you all. Okay, so this is today's topic. Topic is related to two aspects. And the first is the admissibility, and the second is the evidentiary value of the electronic records. So they are the two concepts that we have to discuss. Now, one question will be there in your mind. Then, why we are discussing the Indian Evidence Act when there is a BSC, that is the Bharatiya Sakshi Adhiniyam being enforced? Actually, the cases that were registered before the 1st of the July, whose trial were going on, will be in process as per the provisions of the old criminal law only. So, for that reason, and it's also being mentioned in the schedule, the certain concepts, that's why we are discussing. And in the Bharatiya Sakshi Adhiniyam also, there are no at such certain changes being made. There are certain reforms being made. So before studying the reforms, one must know that what was in the past and what were the things. I will share you this PDF as soon as the class is over. You not to worry at all. Okay. Now, in the introduction, I think there is a no need to make the reading of the PDF in the class. Actually, I'm severely suffering from the sore throat uh, because of the regular classes going on. So, yes. Anyone can tell me what is the electronic record? I think I will try to just make today's session interactive, a two-way conversation session, because there is no as such thing, particular thing to explain in the today's session, and there is no as such draft. So yes, please just unmute your mic so it will be convenient for me also to just take over the session, and it would be interesting for you also, because this is a topic of everyone's interest, that is about the evidentiary value. I think everyone is just like talking about will give you the evidence. Proof पर बात करते हैं हम तुम्हें सबूत ला कर देंगे, हम तुम्हें evidences provide कराएंगे, and the justice system somehow rely upon the evidences also. Either can be the circumstantial evidences and so on. So that's the another thing. Yes. So today's part, I will share you in the detail that PDF, but you tell me one by one. What do you understand by the evidence or evidentiary value? Yes, anyone, please unmute or either put in the chat box. But please don't put the Google copy paste answers. I am just asking, as if belonging to the law fraternity, what you people are just acquainted with the term evidentiary value or the evidence. Yes, please go fast. You are taking so long just to answer. I'm just waiting here. Facts. Okay, Anamika, you have mentioned the term facts. Yes, we can include the facts, but facts means what? Facts can hold a lot of things. Facts can be the universal facts. Facts can be the fact that my recognition is saying, my understanding is saying. Facts regarding what? Anyone else? Case specific fact. Sony, case specific fact. How this can be possible? Either it is a incident specific fact, truthful knowledge in my best knowledge. Didn't get you, Anamika, in the law. Evidentiary value means evidences which is admissible in the court of law. Okay, and Mole, how would you decide that this is admissible or this is not admissible? So that's a very difficult answer, no? Question to answer. Or opinion. Okay, opinion of what? Opinion can't be the evidences. Evidences means that what are the remainings or what are the things being happened, and either you recognize them in the way of either you heard, either you have seen, either you have felt, either you have processed some, saved them, processed them somehow, or either those retain in your memory for long, either you are the witness of those incidents or happenings. So these are the evidences. Yes, anyone else? What is the evidentiary value? Because this is not a topic just who I am going through the PPT and the slide and you are just being like that. And today I have to discuss the same. And the another term is admissibility. I think one of the students have mentioned this. Yes, evidentiary value means the evidence which is admissible in the court of law. What do you mean by the admissible? If the things that are not admissible by the court of law somehow, then they are not the evidences, or they don't hold the evidentiary value. Anyone? Look under the section number 3 of the I think it's visible on the slide also. Does it is visible on the slide? As per the Indian Evidence Act 1872, section number 3, what is not reliable as a concrete evidence inadmissible. Yes, Sony, from where you copy pasted here? Just tell me this also. But by the way, good attempt. I asked you not to copy paste. Okay, so as per the section number 3, now there will be a thing in your mind that what per as the Bharatiya Sakshi Adhiniyam. As per the Bharatiya Sakshi Adhiniyam, also the definition is somehow same or little bit different. Only the difference between the, okay, before jumping directly into the um, uh, today's session, first of all, I one thing I want to tell you. Acha, did anyone can tell me that what is the difference between Indian evidence? Why there is a need to introduce changes in the Indian Evidence Act? What is the purpose the Bharti Sakshi Adhiniyam is serving? What's the difference between both? Yes, sir, one line difference between both. Okay, someone is asking you that, okay, what is the difference between if we belong to the law fraternity? So any client approaching us is asking, ma'am, what is the difference between the Bharti Sakshi Adhiniyam and Indian Evidence Act? Yes, how would you answer this? First, tell me this. Because before jumping into the class, into the topic of the Indian Evidence Act, you must be acquainted with this term also. Yes, anyone, please? Only I think 2 to 3 people are there out of the 23 people, including me, that who are active in the class or either just replying to what I'm asking. Else you just complain to the admins that my voice is just very fast. Students can't get it. You can't get it. If I am asking, then you are also just uh, listening to me but not responding. This is like such kind of a monologue session. Then I think no one is here to just to ready to reply my things. And I'm not asking things that are not other than the law. Changes were made to probably make it all electronic and more with today's need. Somehow, and Amika, you said it right. We make it all electronic doesn't make any sense here. But yes, the introduction of the digital devices, introduction of the digital India, then there are certain offenses that are being committed in the digital platforms. And in the earlier colonial laws, there were no such provisions for the digital crime, digital offenses. Then for the to making them punishable, to make the provisions just to make it align with the today's needs. Okay, Anamika Sharma, allowed emails, etc. I asked what you were trying to say. Allowed emails, etc. Didn't get you. By the way, no worries. The only difference between the BSA and the Bharatiya Sakshara, Sakshara Adhiniam, if anyone is asking you, then you can simply say that under the colonial laws, I think very old methods in the process, not in synchronizing with the present scenario. And the present scenario is about the digital age. It's about the an electronic age where the electronic records are there, where there is a greater chance of the manipulations also. Yes, so as per the Indian Evidence Act 1872 section number 3, there are evidences are there: evidences or the primary or the secondary evidences. Okay, the sometimes court also just like differentiating between both of the kind of the evidences. The today's topic is all about, first of all, go to the title, that is the admissibility and the evidentiary value of the electronic record. So we already know that what are the subject matters that are being present in the electronic mode. Either it's a form of a voice recording or a video recording, it's a audio, it's a PPT, is a digital document. Somehow it's kind in the electronic form. Then that we have to discuss about first of all the admissibility, that those things are being admissible in the court of justice or not, or court are just taking the concern over those electronic records or not. And if the court is taking the concern over those, then if those evidences records are being admissible, then do these electronic records any hold any evidentiary value of the same. So when we discuss about the Indian Evidence Act provision, then Indian Evidence Act provision, under that there is a category of the primary and the secondary evidence. So primary evidences means that the original electronic record is there. If something is happening and you just made the video, then this that is the original electronic record that is you made. Okay, means that the you just producing the document. Here document doesn't mean only the that is the Word file or the PDF file or the zip file. It also means any kind of a audio and the video. Next is the secondary evidence. Secondary evidence means that the party is just unable to produce, but the expert for that particular thing is there, that is being required, or the certified copy or the documents are there, that they are just like they can be on the behalf of that able to produce or just able to licensing. So that is what the primary evidences or secondary evidences are somehow very similar. But the thing is there are certain primary evidences, just like hard disk storages, cloud storages, and so on. So there are certain storages, also certain aspects also of the digital era, that the court has made the evidence admissible in the court, and that are being included under the secondary evidences. Now there are certain aspects that what are the electronic records that can be used as a evidences. So section number 65 of the act is also, sorry, the screen got slipped. Yes, so section number 65 also just mention about the same. I will share you this PPT, and I'm not just reading through the PPT, I'm trying to just explain you the gist of the same. Meanwhile, any of the participant in the class, if it just wish to ask something, then please put in the chat box. We'll like to entertain all your queries. Yes, so there are certain electronic evidences. For example, that particular there is a thing, that is information that of electronic record should be produced by the person having legal authorized to have the control over that organic electronic device. There is a kind of a storage or a copying or making counterpart of the information that are also being required for production in producing in the court of law. And there must be just free from any kind of editing, manipulation, and the so on. And if the stored information that is being there, that can be on the electronic device, can be used during the day-to-day general course for the to just to manipulate the person's action and so on. There are certain kind of electronic records, for example, DVD, CD, hard drives, emails, everything that we do, audio, video recordings, etc. WhatsApp chats are also there. Okay, WhatsApp chats are also there. So yes, my question is regarding to same. Yes, does the WhatsApp chats are the things that is are admissible in the court? Yes. Any how many of you are just saying this thing that the WhatsApp chats are admissible in the court? And anyone please can tell any case law for the same. Next, I will explain. How many of you are saying that the WhatsApp chats? Yes, I have seen them used as a evidence. Anamika Sharma. Okay, you have seen them used as an evidence. Yes, madam. Electronic communication. Yes, Sheetal. Absolutely right. Anamika and Sheetal. Okay, how many of you are agree? Okay, is there any law for the same till now that WhatsApp chats are there just like for the sake of the electronic evidence? Today there is no draft, so we have to discuss this thing only. Audio video recordings are there, emails are there, and then it is followed up by the leading case law, that is the Arjun Pandit Rao case. We'll explain you this case in detail also, but before that I would like to take a record for the same. So what is electronic communication? I am talking about the electronic evidences here. So WhatsApp chat are for the electronic communication, or can be used as a electronic evidence or not? How many of you are saying? Either raise your hand. 24 students are here, and everyone is just like, no one is just putting the attention to what I am saying. Does the WhatsApp chats are admissible in the court? I think they are not admissible. Not confirm about that. Okay. But why you think so that the Akash are the WhatsApp chats are okay? There was a news like that the someone that is being sent by the WhatsApp chat can are to be considered. It has been incorporated in the BNSS and the BSA 2023. Absolutely fine. Yes, these are incorporated in the BNS and BSA. And just few minutes ago, I just asked you one question that is regarding what is the particular differences between the old colonial laws and the new reformative criminal justice system. So there is this difference is only there that old colonial system doesn't have the provisions for the digital world. I am just stop sharing the screen because there is no use as such. Yes, but in the old colonial system there was a thing like, okay, no digital platforms, resources were available, no provisions, the offenses were committed on the via digital platform can be just taken for granted, or taken for the concern in the court. But now when it comes to the new colonial system, then it's like that the court can take the concern over the offenses that are being committed via uh, we can say electronic medium and so on. Now the, uh, we have discussed that there are certain evidences also. Now, when we produce the evidences in the code here, what are the differences? What are the evidences we are discussing are used and as in the criminal justice system only. But there is a one thing that you must be acquainted with, that yes, WhatsApp chats are being included as the evidentiary value, are being admissible in the court, and those are being admissible during all the trials that are being happening in the court, because the data that we obtained from the phone or through the WhatsApp, then it is sufficient just to prove that the accused is guilty. But somehow it's not being as such mentioned, but the data that the police or the investigating officer gathered either from the any kind of electronic equipment, any kind of a email account, then that is being treated as the other document, and other document or the object secured during the evidences. There was a case law also for the same 2021 Virendra Khanna case. I think every student Yes, you have mentioned something. Okay, let me just complete the case law. It's a Virendra Khanna case, and that case is just dealing with the same. Yes, Ayaz, I'm just reading your question. There's one side call recording or the spy recording is admissible in the court. Ayaz, if you are talking about this, then this is a very uh, I can say uncertain thing, because it can be admissible or it can't be admissible. There is no such surety for the same, because if it's a kind of a circumstantial evidence. First of all, one-sided call recording and the spy recording. And spy recording means any third party is recording someone's call, or one side calling. Recording means the person on the one side is just talking rubbish. So these are very circumstantial based things. It depends upon the circumstances, it depends upon the certain facts, depends upon the requirements. And most important is, when we just discuss about the admissibility of the electronic evidences, then their originality is the thing that can be questioned. So it's a very sensitive thing to admit it or not. Yes. If you can give me any other situation or thing, then I would be better able to explain you. Yes, I was just talking about it. Anyone else have any query, then please put in the chat box. Yes, now the data that we are excluding from the WhatsApp messages, or data we are also extracting from the emails, then that can be just like a other document, and the court needs, so then court can consider. Virendra Khanna case is there, na? It was a very famous case of 2021, so you can go through that case also. Now there is a certain thing also, that WhatsApp data is there, WhatsApp photographs, videos are there. And what would happen, does the code is just admissible, code is admitting all that there are certain requirements for the same, that the okay, these are the particular requirements that the evidence must fulfill. So yes, there are certain requirements, the evidence for the WhatsApp kind of evidences, or the electronic evidences. Then there is a one section also, I think section number 65B. I didn't have to bear it right now, but please confirm it. It's a section number 65B, if I'm not wrong. That is just like a prosecution will file a certificate. The students who are going to the court must be acquainted with, who are with the doing the internship under the APO and so on. Then they are just like acquainted with this section, because prosecution advocates are just using this section again and again, and they just file a certificate also. Yes, Arjun Pandit case was there, na? So that case is also just like, what is the how the electronic record produced, for example. It means it is altered or tampered, or there are such modifications or not, or the device produce such type of a data daily or not, and how many persons are just occupying position, that the device is in operation by whom. So these are that things. But now question comes in mind, that what are the particular cases in which these type of certificates are being submitted, and what are the things. So you have heard about the NDPS cases. How many of you heard about the NDPS cases? Anyone have heard about NDPS cases? Please unmute, or either put in the chat box. God knows you have heard about or not. Okay, so in the NDPS cases also, the sometimes the High Court also just consider those cases, and they are just like rallying upon the WhatsApp chats and WhatsApp photographs. Not in my city. Okay, Sony. Okay. It might be like, okay, NDPS cases. Let me tell you where are. The NDPS cases are there in everywhere in the High Courts. Either you can refer to the Punjab and Haryana High Court, you can refer to the Allahabad High Court, and so on. So yes, then in that cases particularly. But now one question important. One question is that what happened if your WhatsApp is hacked? and someone just make the forced photographs, forced videos from modified video, or someone just misuse your WhatsApp account, then what would happen in that case? Is there any remedy or not? Okay, you tell me. This is a very interesting thing, and this is a very knowledgeable thing that you must be acquainted with. If someone hacks the WhatsApp, okay, you are the advocate of the prosecution. If someone hacks the WhatsApp or the email ID and send the spam messages to other colleagues, contacts, knowns, and or then there are certain facts that are being admissible in the courts. The evidences are there. Then in that situation, what one can do? Yes, it's general understanding. You can tell me. Example, suppose two parties while making settlements related to anything. If one party take either call or video recording without knowing of the another party, is this an admissible as an evidence or it will consider as a privacy breach? Look, I ask, there are both the circumstances here. If the evidence, it will consider, it will be admissible as a evidence if there is any kind of a offense being committed on the very same particular time, and those electronic evidences are kind of a third party documents or the other documents, and are just raising the concern about committing the offense, then they must be considered. And rather than the privacy breach, look, there is no as such a privacy laws are there. There is no as such criteria to follow the privacy and so on. And regarding the privacy under the rather than you are just looking for to the criminal laws, you have to go for the writ. So in that case, it's first of all for the it would act as the admissible in the court as the evidence particularly, but those must be correlate or those must support the thing offense or that the mishap is there. It's like that. Okay, I was just asking you one thing. If there is an investigator that obtained WhatsApp messages, but the WhatsApp messages phone without the consultation or without their consent or without their knowing or by illegal means, then what would happen? If there is certain information that is being illegal, then yes, investigating agencies use it for the further information. But you know one thing, always keep in mind, illegally retrieved data is never been acted as evidentiary value, because under the section number 65b, I think, please confirm the section, it's A or B, but the section number 65b is or A is like the prosecution will file a certificate, and that certificate will contain all the necessary details that need to be mentioned. So and this is like, okay, now the whole of the controversy was just related to the conspiracy on the conspiracy case of any of the actors' sons bail. Yes, that's all for the today's topics. What is being mentioned as per the schedule. How should get that certificate? I asked as per the section number 65 A or B. The you no need to get the certificate when the prosecution will file the evidences in the court. Prosecution itself will file the certificate of the same, and it's a mandatory for the prosecution when they are producing the electronic evidences in the court, then they will file the certificate. If the prosecution doesn't file the certificate, that it means that the electronic records that are being produced in the court as an evidence can't be just treated or admissible, can't be treated as the electronic evidence and not admissible at all. So it's mandatory, and the certificate is issued by the prosecution only. I hope you got the answer I asked. Oh, okay, yes. Yes. Anyone else have any query? Then please ask me. And now one thing would be in your mind. that these electronic evidences would work in the case of a civil law or the civil trial. So there is no as such thing. These doesn't as purposely work in the civil law, but they play a crucial role in the criminal justice system. Yes, anyone else have any query? Or you are also prepared with the evidence law? And how many have you start studying the new criminal laws, and how many have you completed? Let me know. How many have start studying? Okay, good going, Anamika. Did you complete started? Okay, okay. BNS you have started. Sakshi Adhiniyam, Bharatiya Sakshi Adhiniyam. No one have started studying the Bharatiya Sakshi Adhiniyam. Okay, whatever the PDFs I have shared in the previous session, do you go through those PDFs? Please go through that PDFs. The days which pass, the course will over, and you will be like, what you have learned. So please go through those PDFs and make a draft of all the PDFs by your own on the paper. Okay. So yes, and it's all about the today's session. Today's topic. Now, please, anyone else have any query? Then we'll tomorrow we'll start with a new draft. Want to ask something about the electronic evidence? Please just clear your doubt. Law is all about clearing your doubts or study. No one just unmute. No one just put in the chat box except one or two students. Yes, Sony. Ask. You have raised your hand. Electronic evidences are the circumstantial evidences, but now play a crucial role in the new criminal justice system. And this is a need of the time also, because everything is going digital, and then to just stop the cyber crimes and so on, there is a need of electronic uh, evidences to be admissible in the court. They must be considered. Did you get the today's concept? Then gives a thumbs up. Uh, is there any judgment for accepting the WhatsApp chat as an evidence? Yes, there are two to three judgments. You can refer to them also. That is the Virendra Khanna judgment is there. Where Virendra Khanna judgment of 2021, I think. Yes, 2021 Virendra Khanna versus State of Karnataka, very important judgment. That WhatsApp chats or the data that we gathered from the email account. It is just like it doesn't prove the guilty of the accused, but it's just like any other document, and these must be considered and should be treated as any other documents or not the direct. Another case, but Arjun Pandit Rao case is also there, that filing of the certificate is mandatory. So these are the cases. Now, if the police take evidence without the consent, and the police accuse him of a crime, is that also a self incrimination? Look, one thing, if the person is if the not person, if the investigator is just like obtaining any kind of a chats or videos or something, and from the mobile phone of a person, and there are just like without their consent or without the hacking is also there, or any kind of a tampering or any kind of illegal means, then it means that the uh, data would not have any such evidentiary value. But it's like na section number 65b and b is like that the certificate must there, that there is a category like no tampering with the electronic record and so on. And if there is illegally retrieved WhatsApp messages, the agency couldn't be able to find those at that certificate under section number 65b. So that is not admissible, and not moreover admissible, that doesn't hold any kind of a relevancy. Yes, Sony. I hope your doubt is clear now. Because to make any of the you take this in a very easy way. If to make any of the electronic evidence as a arbitrary value, as to make it admissible in the court, do one thing. one thing is great that the prosecution must file the certificate, and certificate containing the information. No tampering is there, no modifications is there. So it's mandatory to file the certificate. Section number 65B is there, I'm pretty sure, because I just prepared this 1 year ago, but I'm pretty sure. Yes. Anyone else? I think no one else has any question. If you get the concept, then please give us a thumbs up, and then we'll ask the legal Vidya. Okay, Namika. Yes. Anyone else? All are very acquainted with the concept with the. Okay, so I think one task must be given to you all uh, for today's session. Okay, I will share the task in the group itself. I am just thinking of you to give the task related to the admission of the admission of the legal records. We'll prepare the question, then we'll put in the group tomorrow. Anyone else have any query or the question? Then please ask. What tomorrow we'll share a new draft as per the schedule. Yes, I think no one have. So legal Vidya, kind request you to wrap the session because today's topic was this only. No such draft was there. I think they are not there.
Thank you so much, ma'am. Thank you so much, participants, for joining. Let's wind up this class. Thank you,
Thank you.
everyone. Good night, everyone.
Good night, Legal Vidya. Thank you, and thank you, dear participants. If any doubt arise, then ping me just a text away. And happy learning. We'll meet you tomorrow in a new session. Thank you.